morning, everyone. I feel proud in welcoming you all at IIPLA Global IP and Pharma IP Summit 2018 London. And on behalf of International Intellectual Property Law Association, I want to thank our eminent speakers, distinguished delegates, and our sponsor and partners for making this conference successful. I especially want to thank BSKB for sponsoring us, and they have been very kind to us. So in next 2 days, we'll be covering various thought-provoking discussions. So we have 8 sessions which are spread into 2 days. In session 1, we'll be discussing about the progressive development of international intellectual property laws by Cartin Turner. She's already there. In session 2, we'll be discussing about the amendments in patent law and recent patent infringement case in pharma industry. The speakers will be Kristen and Gerald. And in session 3, we'll be talking about the technological and legal development in intellectual property. Justin, Bastion, July, and Sainia will be the speakers in this session 3. In session 4, we'll be talking about the evolution of IPR in SME and high-tech industry. Gavin, Helen, and Kevin will be discussing in this session. In session 5, we'll be talking about the link between IP and high-tech industry. D. Santo and Dr. Roya will be the speaker in this session. In session 6, we'll be talking about the evolving role of IP, and Debolina and Nick will be speaking in this session. Session 7 will talk about the standard essential patents and friend licensing. Telly and David will be speaking in this session. And the last session that will be on the day 2, and 7 and 8 will be on the day 2. This session will be talking about the TRIPS, WTO and IPR, prevailing issues and emerging trends. Dr. Muhammad Al-Quda, Philip, Edwin, and Lisa will be speaking in this session. So I believe that everyone will have good interaction in these sessions. So as a small group, so we can have more interaction and try to make this conference more successful by interacting more in these sessions. So I wish you all a very good luck and a pleasant stay in London. Thank you so much.
Thank you, Azam, and I hope you all will utilize this wonderful opportunity to contribute to IIPLA. Now we'll begin our first session. This session will focus on progressive development of international intellectual property law. And the speaker we have for this session is Cartin Turner. She's the IP counsel at Airwire International USA. I'm sorry if I mispronounced anything. So from here, Cartin will take us over.
Thank you. All right. Hello, good morning. I'm going to talk about shoes. Airwear, you may know as Dr. Martens. Hands up anyone who's ever had any Dr. Martens, ever had a pair. This is quite amazing for a lawyer's conference to have this many wearers. Most people, if they've had a pair, will have a story about it. And that's what our brand and why our brand is global, because people have personalised our brand. When I was sitting waiting, I looked over and there are 3 jars of sweets over there. And what's really interesting is there's some jelly beans in the middle, and they've actually put a little sign that says jelly beans. And I don't think any of us in this room really needs that sign to know those are jelly beans. And that's what we as brands lawyers, that is the holy grail for us. I just wanted to make a quick comment about the Louboutin case, which has just been decided this week. As someone in the iconic shoe business, it's tremendously reassuring for us because we feel that there is a wave of copying going on, and if the courts don't support us, iconic businesses that create genuinely unique-looking products are going to struggle. As a Londoner, I was very depressed by the taxicab case, which was a case to do with whether or not the black taxi could be a registered trademark, and that was denied. But Louboutin, they keep fighting the fight. I also saw this morning that Barber is suing Levi about the tab on the back of their jeans. That's also on the top of Levi also suing Kenzo. This is for those of you who are in private practice, this is a tremendously litigious area. It is an area I think is really exciting. I got a friend at Levi, and we talk a lot about the challenges for us internationally, and we are on the same page in terms of our non-traditional trademarks, which is that we have to use them or we will lose them, so we have to sue. That's the good news for you in this room. So I'm going to set some context first, and then I'm going to talk about 5 areas where we're seeing real development in terms of how we're using international IP law. I'm not going to apologise for talking about shoes. It's what we do. As providers who want to advise us, we do expect you to wear our product. We do expect you to know something about shoes. There is nothing more depressing than coming to see an advisor to talk about non-traditional trademarks and they have made no effort to look at who is doing what in our field, because all of us are pushing at the same envelope, whether it's us, Vans, Timberland, Camper. We are all trying to get more trademark protection for our shoes, and if you want to work in this field, you need to be interested in shoes. Okay, so we are global, obviously. We are 400 million, going for the 500 million. We'll be 1 billion, hopefully, within my career. But we're growing very, very fast. But so are our copiers. The days when copiers were selling on the street are gone. It's all about online. And again, I would say to you as lawyers in this field, if you want to work in consumer brands, you have to understand how online works. You have to actually, for example, shop online. If you don't understand how the likes of Alibaba, Amazon, ASOS, eBay, whichever platforms are the major platforms in your country, if you don't understand how they work, so it's going to be extremely difficult for you to help me stop copying. So it's still the same old story. It's still about lookalikes and fakes. That is never going to change. From my perspective, lookalikes are much more damaging than fakes. Fakes, and I will talk about this, there are systems that make it easy to spot them and more or less easy to take them down. Lookalikes is much more of a challenge, and I'll talk about how the online platforms treat lookalikes and why it's such a challenge. But from my perspective, those in the lookalike business are parasites who will kill the host. They will look alike a brand until it is into oblivion. So that is our main fight, and where the likes of me or Levi or Louboutin are, we are trying to stop people taking the unique essence of our brand and making it generic. There's a footwear brand that I'm not going to name because I don't think it's fair, because they're not in this room, who told me they recently had a ruling from a court in Europe that their outsole had become generic. Now that's the terrifying, that's the point at which I go to my board and ask for more budget, because I can say we know the road that we could be down if we don't fight our enemies. So this is just an example of our shop. This is our shop in Lyon. We do have shops. We have lots of shops. And our shops are very important to us. And if you watch any of the commentators on the growth of modern retail, they talk about the fact that it's about omni-channel now. So it's not about going online and forgetting about shops. Shops are really important to us. But in terms of where we're copied, it's predominantly online. So here's an example of our online offering on the left, and on the right is the ASOS, a page from the ASOS website. ASOS is a customer of ours, as you would expect. All the big marketplaces are. So Zappos in the States we sell to ASOS, we sell to some of the European websites as well. We obviously sell to Amazon, we sell via wholesale partners into eBay. So we're in this space, and that to some extent sort of confuses the legals, because it's not, we're not in a Birkenstock type situation where Birkenstock or Lush refuse to sell to Amazon. It makes it much easier for them to control things like keyword advertising. We're actually dancing in this space commercially, but also trying to control how our brand is used. So what do we protect? Those are a selection of our word marks. These are our traditional word marks. When I joined the company 2.5 years ago, it had been a family-owned business for obviously many, many years. This is the British footwear industry started in the Boer War. This is how long some of this business has been around. Making army boots, First World War, Second World War. The family business that became Airwear was a business in the shoe area of the UK, which is Northampton, that was approached by some German inventors who had created an air sole. And the combination of the air sole and the footwear know-how of the business led to the creation of the Dr. Martens. When I joined the business 2 years ago, pretty much IP protection was about keeping the core assets safe, which means these word marks, and it means predominantly these logos. And it was an element of, if we keep them safe in every country of the world, that's all we need to do. Now, I come from a litigation background. I spent 25 years in the city litigating, mainly actually for now my enemy, so for retailers. So I did a lot of work for the likes of Tesco and Asda. I did the original Tesco Levi case. So I've been on that side of the argument. Coming into Dr. Martens, what struck me was that this wasn't protecting our core asset. Yes, it was dealing with counterfeits, but if you look at lookalikes, generally they're not sold as Dr. Martens. If they were, they'd be a counterfeit. What was being taken were versions of our name, were versions of the look of our boot. This is our trade dress. For those of you who have had a pair of Dr. Martens, you will recognise the profile of this boot. This is we have a number of icons. This is probably our best known icon. It's called our 1460 because it was actually the first pair of boots came off the production line, 1st of April 1960. That's why it's called the 1460. We've got a shoe called the 1461. We've got something with April Fool's Day. We keep launching product on that date. But if you look at this slide, this is what we say is our trade dress. And what we've got here is we've got a heel loop that's 2-colour, which is yellow on black, and it does say airwear, and then it says with bouncing soles. We have a yellow, what we call a welt stitch, which is a stitch that goes around the edge of the boot between the upper and the sole. We have the sole itself is very distinctive because it goes from dark to light, and that's to do with the way the welting and the PVC is done. And it's got a lateral groove across it, so it's got an effect, a sort of deliberate aesthetic shape added to the edging of the sole. And that was created because when you welt PVC, you end up with a ragged edge, and it was about how we were going to trim it. And we had a very brilliant a member of the business in the 60s who understood aesthetics and started to create some of these elements of trade dress. And then we have a sole pattern, which is, sorry, the picture's not very clear, but it's our sole pattern. If you had a pair of Dr. Martens, you'll know the sole pattern. Every rock star has kicked out in a pair of Dr. Martens. You can see the sole. It's very well known. It's also, I believe, it's not also on the Metropolitan Police database for burglaries, but that's just a side piece of information. So, what are our challenges? What on earth are we going to do? We are faced with a wall of fakes and lookalikes, an absolute wall. The volume. One of my chief frustrations with external advisors is they treat each issue as a standalone case that can be treated like it was always treated. So they want to spend hours doing a cease and desist and then hours advising on litigation. That doesn't work when you've got thousands and thousands of cases. And that model just is not sustainable. This is an example of the sort of thing that we're seeing coming out of China. And I put this example up because it's indicative of the real worry in China. I was sitting with one of my Chinese advisors having a very nice lunch. I did look at some sushi and say, "That's lovely, what's that?" And he said, "Donkey," and I laughed. And then realised he was completely serious. It was actually very, very nice, but I thought he was joking initially. Anyway, he said to me that the country that has had most problems in China is the country with the most sophisticated IP, and I am actually looking at some Americans in the room because I heard your accents earlier. He said the reason is because what that country hasn't understood is that in China, small issues become big issues. As IP lawyers, we look at issues in China and go, well, that's really small, or that's an individual, or they don't have a factory. You know, we don't, at the moment, because of the wall of issues, we don't have to worry about that. And that's caused some big issues for US companies because what's happened is, as they call it, small fish, big fish, the idea that if you leave the small fish in the pond without fishing out, it's going to grow and get bigger and bigger. And a number of brands have found themselves in situations where, in the time it's taken them to launch in China and create retail, a completely parallel brand has created and maybe tripled the number of stores. So this is an example for us of a real concern, because what they are doing is they're not copying us in a counterfeits perspective. They are creating a parallel brand. If you look at what we call our bouncing ball, they've taken parts of it and not other parts. They've added their own to it So it doesn't say Dr. Martens, it says Mikkel Martens. Now, the product itself is not bad quality. It's not coming out of our factories, but it's not bad. And we believe that these guys are about creating a parallel brand. That's a much bigger issue for us than having counterfeits being sold on Alibaba. Another point I wanted to make, which is really important, is about multi-country listings. So I had a sit down with Amazon at the last INTA, and I said to them, my issue is the likes of this trader is called Jack Shibo. And Jack Shibo is listed, I will initially have found him probably on .com or .co.uk, but Jack Shibo will be listed on all the Amazon platforms. But the way the Amazon platforms work is they only work country by country. And what Amazon was saying to me while were wringing their hands with sympathy was, we didn't build our platform to connect everything. So what we have on one platform doesn't speak to what's on another platform. I'm not sure if that's right, but that's what they're saying to me. But that means that when I need to do takedowns, I've got to go platform by platform. I would like Amazon, if I identify a trader, to tell me where that trader is. They're saying they can't do that at the moment. But that means, again, it increases my workload. This is another slide showing some bastardization and commoditization. And it's a slide of what traders are doing to try to make it difficult for us to stop them. So they cut our brand about, they split bits of our brand up, so they'll put doctor and then some words in, they'll put Martins, or they'll spell Martins wrong. So we've got here, and if you look, what they also do is they obstruct our logo, the actual image, so you can't see the image. So there's all sorts of ways they try to get the product to comply with the online marketplace rules, whether that be Alibaba or Amazon. And so we can't get it off. And then we're forced to consider having to sue, which clearly is what we don't want to do because it takes time and money. What does this mean for us in this context, for international work? First of all, it means we have to have eyes everywhere. I was talking to my Italian lawyers, and we've got a case going on in Italy, and I'd had quite a big bill with no warning. And I was gently freaking out on email saying, why do you want to send me a bill for 30,000 euros? And he came back in a very sort of urbane way and said, well, if you remember the case we did 5 years ago, there are ebbs and flows in Italian litigation. And I said to him, that's great. I'm watching the world. I don't have time to take note of the ebbs and flows in Italian litigation. I just need warning about invoices. But it was an interesting perspective because if you are working as we as lawyers tend to work country by country, one of the things that's really important to understand is that we in-house are looking right across the world. And that even comes down to the fact that I spend substantial amounts of my time in Asia. So we got time difference issues, we got email issues. I get antsy emails from advisors saying, you haven't answered my email. I'm like, I'm in Shanghai. They keep turning my email off. When I'm in China, my email goes on and off. Sometimes text works, then it doesn't work. Sometimes WhatsApp works, then it doesn't work. My poor paralegal, we go round the various modes of communication to get messages across. But we understand that, but often our advisors don't. Disputes in unfamiliar surroundings. We have all been trained in one jurisdiction. We know the courts, we know our colleagues, we know the judges. I'm going to talk about some of the advantages of that, but the thing to bear in mind is that we are often looking at multi-country disputes where some of those countries we may never have litigated in before. And then the third point is that we are trying to push the inside of the envelope from an IP perspective. So the way I look at it is I need to at least try to get more rights. The more space I occupy with my brand, the more I push copyists back. And one of the things I find with advisors often is they think that they shouldn't suggest something which they think will fail. So I find this particularly in places where I can't meet the advisor face to face, and I'll have loads of email where I say, look, just file, and they won't file. And now I know that, for example, with trademark attorneys, to some extent the role is about keeping things safe and doing things in a safe way. But I need to be able to say, I need you to take a punt here. If I look at my peer group, so Vans is a very good example of a brand that in China has adopted what I would call spaghetti on a wall. So they've literally just thrown trademark applications at the SAIC to see what will fail and what will be accepted. Nike have done the same. That's the only way to go. And so as advisors, although obviously I need you to be clear about prospects, I do need you to say, as my wonderful Chinese advisor says to me, you know what, Katrin, We won't get it through in the first round. We'll have a fight on the second round, but let's just start. That's what I need to hear, because I need to move forward. I need to create more space around my brand. Example of pushing the envelope. This is a flat version of our heel tab. The one on the top is the one that we use, but both of those have been registered as copyright in China. Now, the one on the top I have registered as a trademark. The one on the bottom, for reasons to do with the way we're organised, I will have as a trademark, but in the short term I needed some registered rights for takedown in China, and therefore I used Chinese copyright, which is quite quick to get. There's a bit unusual, there's quite a lot of paperwork to fill in, but it means that when I'm looking at marketplaces, I'm looking at lookalikes, it's the tab on the bottom which is what is copied, not the tab on the top. So the lookalikes take the word airware off my tab and just use the bottom version. If I try to enforce my rights with the top and say, but I've got a trademark, you must take this product off, they'll say, I'm sorry, we don't get involved in whether or not it's confusingly similar. If you want a ruling on confusing similarity, go to a court. I want product off the marketplaces, and Amazon and Alibaba are no different in the way they deal with this. You need to have registered rights that exactly mirror what is being copied. So if necessary, you need to go out and register versions of your mark. I was talking to my peer group, and we all are in the same position. We are busy deconstructing our core brand and registering bits of it to try to mark what copiers are doing. Some other defensive trademarks we have applied for. So on the top left is the Michael Martin's brand. If you saw a few slides back, we were talking about Michael Martin's as a brand that I'm concerned about. One of the things that I've done with Michael Martin's is that I've applied for their trademark. And the reason I've done that is because I want the ability to take their listings down. Now, they may well come back to me and say, but it's our brand, and I'll go, tough, prove it. But it gives me, as a litigator, it gives me something to fight with. Now, I had our trademark attorneys hyperventilating about this, saying, but we're not going to use it. And I'm like, well, we'll deal with that when we deal with that. I need something to fight these guys. And at the moment in China, I'm struggling around 3D trademarks. I've got an example in the middle of a 2-character Chinese trademark. It's actually the horse symbol. So Jack Ma, for example, of Alibaba, that will be part of his name. It's the horse symbol, and then it's a large J, and it actually reads as Ma Ding, which is how our name is transliterated in China. That is in the traditional form, although modern Chinese would use a modern form, but if you go to Taiwan and Hong Kong, they use traditional form. But the two are pretty interchangeable. But again, as I said, when I joined the company, we thought we'd done our job because we had Dr. Martens registered, and no one was looking at how our brand was being used online. And in China, the keywords are in Mandarin, so it's not enough to have Dr. Martens. In the middle, I've given you a soul pattern, but that's only part of our soul pattern, so it's a deconstructed soul pattern, and I've registered that as a copyright in China. And then on the left-hand side at the bottom are some examples of common words used to refer to our product. These are words that copiers use. So if copiers use them, we're going to register them. These are very successful because as soon as we get them through, particularly with Amazon, we send them to Amazon, they start taking listings down. So how can international enforcement actually help us? We've talked about some of the challenges, but how can it actually help us? I'm going to make 5 points. The first one, systems to sift volume. As I talked about the huge amount of volume, we cannot treat each case as a separate case. I need the ability to get through volume quickly, and there's where the growth of the sort of more modern online providers are coming in. So the likes of Yellow, Pointer, IncoPro are all there with teams of analysts who are looking globally. When I arrived at Dr. Martens, we had an online watcher, but no one spoke Mandarin. So we weren't watching Asia. It was just in nonsense. We now have a team that's a multilingual team, so I can basically fire anything I want to at them. I particularly look at Japan. For me, Japan, China, America, UK, Germany are our big sort of markets that we're watching. I'm developing my own team in Shanghai because not only do I need people who speak the language, I need people who are connected. As a British brand, we're also members of the China-Britain Business Council, if you don't know them. Tremendously well connected, particularly online, so they can get you meetings into the right platforms. I'm in Asia next month, and I will have a chance to sit down with the likes of Alibaba and some of the newer platforms for us like Douyin that are really important. Just a point of warning on this, when you're using analysts to sift volume, be willing to take care around takedown. On the left is a fan site, on the right is a fake Facebook site. The fan site got taken down, which it shouldn't have been, even though it bends our brand. The fan site should have been spoken to, and we should have got to an understanding about how they can use our brand. Our brand is about self-expression. But a dumb and rough approach led to takedown. We now are in a situation where we look at all takedowns before they go through. Nothing is automated. I'm desperately waiting for some of these providers to start using the sorts of technology like AI, which will mean that I can do less touching of this stuff. At the moment, I do a huge amount. And I was listening to an ad for Uber this morning, and they were talking about how every ride improves the service. And that's the case with, all of these places like TripAdvisor. I'm not seeing that on takedown yet. That's the next stage for us. Multiple geographic touch points. Oh, what a wonderful sight it is to see that on a website, because I know I can start picking and choosing jurisdiction. So I can have a UK retailer, I can sue them anywhere they deliver. And I do. And my actual forum of choice is California. Another site, this is the Amazon where we deliver to, which is basically everywhere. Particularly for me, they deliver, obviously, even I can buy product on amazon.co.uk and have it delivered into the US and establish jurisdiction. Fewer channels who matter. This is the consolidation of the market. It's a nightmare from a competition perspective, but from an IP enforcement perspective, it's very helpful because it means I can get to know a few platforms really, really well. And obviously, in terms of the sort of English-speaking world, these are the key ones. This is where keywords come in. So I just put one slide up showing how a search result is peppered with keywords. Once I go into those listings, I'm also looking for things like doc Martin with an I, all those sorts of words I'm looking to protect. Here's the Chinese ones that matter. If you don't know these logos, it will be worth familiarising yourself with them. I also would suggest, if you don't know that much about Alibaba, that you read The House That Jack Built. It gives you a really good sense of how entrepreneurship has grown in China and the interrelationship between the likes of Alibaba and Tencent. It's really, really good book to read. I did also read The Shop of Everything about Amazon, and again, I found that very helpful, particularly around that attitude to marketplace and attitude to competition. Because for us, once our brand's on Amazon, it's a sort of free-for-all, and that's very unsettling to our sales. But I'm like, that's what Jeff Bezos wants. It's not going to change. This is just a really bad photo of someone else's WeChat. I asked them to open WeChat for me on their phone, one of my Chinese colleagues, just to get a sense of how much you can do through WeChat, how massively broad this platform is, and how important it is, if you're a brand, to understand how WeChat works. This is a slide of some of the transliterations that we have in China. So as a trademark protection and enforcement specialist, I need to understand how our brand is being used in key markets. I need to go to my business and say, what are the key words that are being used to find our product online? And those are what I'm trying to protect. Those are what I'm trying to register. And as you can see, there are many, many ones that involve Chinese characters. I had a domain expert come to me and suggest what they had alighted on the idea of Chinese transliterations, but they didn't understand how things worked. And they were strongly suggesting to me that I try to register the 2-character Mandarin Marding.com. And I'm like, what consumer is going to flip between two different sets of characters in the middle of a site typing an address? It's not going to happen. So if you are working with clients who have businesses in Asia or have factories in Asia, or there's any sort of risk around copying, I strongly suggest you start talking about transliterations. I'll give you a story here of another footwear brand, New Balance. New Balance have got an ongoing issue with a parallel brand that has set up its own stores under the name New Balance, but in Mandarin. And New Balance keeps getting sued by these guys, and New Balance wins some and loses some. But if they had the transliterations registered, it would not have happened. So we're very vigilant. Retail distribution complexity is a massive advantage for us because, as I said, when I find a product I want to take action on, generally I will decide what my jurisdiction is, and I will generally not choose the home jurisdiction of the retailer. And that was brought home to me because I was looking at some old files and I saw a piece of litigation that we had done many years ago against a retailer in Europe. I'm not going to say which one it is. And they were a serial copier of us and many others. And we sued them in their home jurisdiction and they wiped the floor with us. And I was looking at the files thinking, we got them on ex parte injunction, that got overturned. We had them on contempt. And I don't know what happened in that courtroom, but the contempt didn't stick. And then the penny dropped. That retailer has the best team. It knows all the judges. You are operating on their battlefield. Don't do it. Pick a jurisdiction that is not the home jurisdiction of your opponent. And the wonders of modern e-commerce is you have the ability to do that. Another retailer, it's a British retailer, we sued them in the States, and they said to us, well, you can't sue us in the States. We don't sell in the States. And we said, yes, you do. They said, but we've only sold a few. And we said, yes, probably all to us. But you've sold them into the States, and we have jurisdiction. So this also is a very relevant in terms of advisors, because I've had advisors who come to me representing their clients saying, our client is not infringing in their home country. And I said, that's great for you, but I've got the world to play with, and you can advise your client on your home jurisdiction. What about US? What about France, China, Japan? All the places we've got rights. So as an advisor, you also need to be very well aware with your clients, if they are in the retail or wholesale business, that they have liability all over the place that they're selling. And your advice about what infringes the home jurisdiction is not, we're not necessarily going to play that game. We're going to choose jurisdiction. Just a very quick slide about how Alibaba works. I think it's important that you understand, particularly about how their platforms work. So if you look at the second from the left part of the slide, it's got their marketplace. So you've got Taobao at the top, you've got Tmall, you've got Zhuzisan, and you've got AliExpress. The ones that we worry about are Taobao and Tmall. Tmall is like the more high class, the sort of shopping mall. They have, very much want European brands on there. Taobao is more sort of smaller traders, everything is on there. Taobao clearly is a bigger issue around copying. What I didn't understand until I sat with one of my Chinese colleagues is, if you are in China and you search Tmall, because Alibaba also owns Taobao, the search results that are served up to you include Taobao. So although I had thought I need only worry about Tmall, I need to worry about Taobao. But again, it's about understanding what the consumer is going to see. One of the things that we do, and one of the areas where we've had to deal with the issue of volume and find a way to deal with it, is to try to knock off some of the copying before it becomes a big issue. And for us, it becomes a big issue when the product is actually on the shelves, because then what happens is you're forcing your opponent into a corner. They've got product on the shelves, they don't want to take the product off. There's all sorts of complicated issues about who's liable, is it them, is their supplier. So what we try to do is go out and talk to retailers about what our trade dress is. And we assume the good. So we will talk to all retailers respectfully, and we will say, you may not have realised that we have all these rights, and we will lay out for their lawyers what our trade dress rights are. Our trade dress rights are held in the name Airwear. We are Dr. Martens. Even the best, most careful retailers, if they search Dr. Martens, will not find our trade dress. And that's the issue. That comes from me being on the other side of the fence in a previous life and understanding how clearance is done. And clearance is done on the basis of personal knowledge of lawyers of which brands have trade dress and which brands will sue. Our job is to get out to retailers and say, this is our trade dress. And by the way, we do sue. Why don't you Google us and Steve Madden? We tend to do a couple of strategic litigations each year to make it very clear that we will sue. The next challenge, voice. You may think, well, why is that relevant to us? It's massively relevant to me because people are going to be ordering via these systems. Obviously, that's the Alexa. They're going to be saying, Alexa, order me a pair of black Dr. Martens. I need to understand what's going to be served up. There is developing technology around this. It's a massive issue if you're a trademark lawyer because your ability, number one, to understand what keywords are triggering what brands is massive in terms of being able to effectively help your clients to protect their brands. I'm presenting to our board next week, and the theme and why they want to hear from us is they understand that with a consumer product which is iconic, the IP is central to value. We're not just about trying to protect trademarks. We're about protecting the business and the profit margin and the positioning of the brand. So things like voice, I've said to my digital head, I want a couple of Alexas down in legal, and we're going to start talking to them, and we're going to start firing questions. Send me an 8-hole boot. Put a black heavy sole shoe on my list. Once I understand how Alexa is working, I can then go to Amazon and say, right, how are we together going to curate our brand? We are a customer for you. You want us there, but at the moment, we just don't know whether actually whatever you assure us in terms of the website is actually going to work on Alexa, or are we going to see a wall of copiers coming back to us? And I think that's it. Thank you very much. Any questions?
Is there any questions from the audience?
Yes.
Thank you. Firstly, I love your shoes.
Oh,
I've got a great
fantastic.
pair at home. What I wanted to ask was, what are the factors that lead Birkenstock to just say, we're not going to play with Amazon, we're not going to play with these kind of online marketplaces, yet Airwear are willing to play? Because it seems to me either one of you is wrong, or there are different factors at play here.
If you get a load of brands in the room, it will be one of the main topics to dance with the devil or not dance with the devil. Because it's not just Amazon, it's Tmall in particular for China. It's about sales versus curating your brand. At the moment, we operate a mix. Birkenstock are very interesting culturally. So, for example, all of their manufacture is still done in Germany. It's still a family-owned business. So they are still very much in control. We are private equity owned. We are already, global. The relationship with Amazon, we've been off Amazon, we're on Amazon. Whether we'll take a Nike view and start to look at what product we are willing to put on Amazon, so in the way that we call it assortment. So even with all of our retail customers, we decide who's going to have what based on where they are in the market. So, a mass chain might have our more mass product, but then if you talk about sort of our high fashion, so we do, for example, we Yamamoto stocks our product, Comme des Garçons stocks our product, but they have a very different assortment. So I don't know where we're going to end up, and it's a constant conversation within the business with the sales guys, and then me saying, you do realise, don't you, that if you put the product on, I can't stop them selling it anywhere in Europe. But it's not just Amazon. We had a chain that came to us, one of the big fashion chains that's based on the continent, and they came to our sales team and they said, we'd like to order 55,000 pairs of this product. And sales were like, yes. And we were like, hang on a minute. And I have a case room with all of my lookalikes in. And I came out and I said, this is what they've been doing. This is a lookalike. Having a physical example helps. How many stores have they got? That's 100 pairs a store. You can bet your bottom dollar they're going to put a Me Too product in. We shouldn't do it. And unusually for our business, the lawyers, we have an equal say on this. We said, you're not going to do it. You're not going to supply them. And they're like, okay, fair dues. Not saying we'll ever get a chance to say, I don't know how I feel about Amazon. I don't know. I'm absolutely on the fence about it.
No, it sounds a lot like as the market changes and adapts, you have to move with it.
Yeah.
And it's about being alive to that.
Yeah.
Okay, thank you.
There's a question.
My firm deals a lot with the SEMA organization, which is Aftermarket Automotive, and we deal with people who are just starting up. It's what I would call it a second generation industry, just now turning over. So when you're not iconic and you have limited budgets, what would you indicate they should, because they are fighting a lot, and we do a lot of the takedowns in the same manner, well, certainly not the same manner, but theirs is often the small fish. Well, we'll get them next year, or just hang on. What is if you had a limited budget between copyright, trademark, transliteration, and all those, and I'm fighting all of those inherited from other attorneys, what would you advise them to prioritize in terms of protection in China, just to get the rights to start the takedowns? And I think in our case, I see the development of what you finally identified that I find encouraging, the parallel brand. It's the first time I ever heard that. So.
I would say that you have to start from what can you do that will cause friction, will make it more difficult for the product to sell. So how can you bury that product? Because it's only going to sell if consumers see it, if it's a consumer brand or whoever the customer is. And so we started from the perspective of how can we make it more difficult for them to associate with us. So let's look at, terms like DocMart, you might say, well, that's completely non-trademarkable. We've got it trademarked. So look at some of the terms they're using to sell the product, because if they're making versions of, they have to associate. The consumer is not telepathic. The consumer has to be given some idea of why it's an equivalent product. So I'd look at trying to attack those keywords. And then I'd also look at making sure, for example, on those platforms where the Me Too products are being sold, that you are on there. Because one of our issues was that, for example, in Russia, the social network is called VK, and we weren't on VK. And if there's a gap in the market, they'll fill it. So what was happening was parallel product was coming into Russia and being sold on VK. So once we provided an authorized outlet, then customers would start to buy from us.
Is there any more questions?
If I've whet your appetite, there are some fantastic Dr. Martens stores in London.